Yes, good evening to you, everybody. Welcome to the today class. And yesterday that I announced that I am going to teach today the nuisance. Please read what I posted on the screen so that I could know that you are with me and I am with you. Hurry up.
The word nuisance is derived from the French word nuire and the Latin word nostri, which means to do hurt or to annoy. Blackstone described nuisance as something that worketh hurt, inconvenience or damage. Nuisance is an activity or state of affairs that interferes with the use of enjoyment of land or rights over land or with the health, safety or comfort of the public at large. In simple words, nuisance is an injury to the right of a person in possession of property to undisturbed enjoyment of it and results from an improper use of by another person of his own property. Professor Dr. Mohammed Saheb Hussain.
What is the next image?
What other word? Image?
This one.
Image of.
Why she is feeling uncomfortable?
Yes, sir.
Why she
Because
is
of
feeling uncomfortable?
insect, mosquito over there.
Is it mosquito or insect or bee?
BB.
Yes, it is producing some sound that she will be inconvenient. What about this one?
Two pigeons.
What is written over there?
What are other words for nuisance? Annoyance, bother, trouble, inconvenience, vexation, plague, pain, pest, irritation, irritant.
Uncomfortable also, inconvenience, annoyance, restlessness. So these are all the things which causes the enjoyment of his own land or the property or the things. Then somebody is infringed it, then he is creating a nuisance. Then what about here?
A girl is disturbing the man.
How he is disturbing? How she is disturbing? By kicking or keeping her two legs and causing inconvenience because he is reading the paper and this girl enjoying a smartphone, something in the hand, and making the kicks over it, and he felt uncomfortable in reading it. So she is creating the nuisance. Since morning till evening, you also create the so many nuisances, knowingly, unknowingly. Knowingly, unknowingly. So let us see without wasting the time. So this is also a nuisance. Sir, how could we, suppose you are going on a public highway, there the crash would be there with the other vehicles. So traffic jam would be there and you are uncomfortable to reach to a particular place or you miss your plane. So many things will come over there. So this is the public place, hence we can say public nuisance is created. If it is a private place, a private nuisance is created. So that is the way. So here the wrote the public nuisance. The main aim of the chart of the public nuisance is to protect the general public from unwarranted disturbances. So here the met with an accidents. So there is unwarranted disturbance would be there so that the person could not enjoy to go reach the railway station or bus stand or the aerodrome. An action for the public nuisance is only available if the plaintiff can show that he or she more affected than other members of the public. A common example of the public nuisance is blocking of a public road. Is one dug it up to use it as a part of his farm. Because the plaintiff was a neighbor of the defendant, he could demonstrate that he suffered more inconvenience than other members of the public. Then even a public nuisance became a private nuisance because he suffered more than the other people suffered. Public nuisance actions nowadays, civil cases under the chart of public nuisance are relatively uncommon. Activities causing the public nuisance are more likely to be the proceeded against a criminal prosecution. So very rarely the people will file a case regarding the public nuisance creating the private nuisance. But generally the public nuisance, the criminal prosecution should be there. Because this is because of the nuisance act usually involves a breach of the legislation and the mass will be suffered. This is another factor. Commonly prosecuted by the crown, but the crown is not there. It is the PP on behalf of the community. Example include the action that endangers the lives and safety and health, comfort of the members of the public in enjoying the use of the highway, parks, or waterways. So the public nuisance would be there. And the private nuisance, read. Unmute and read.
Typically, an action for private nuisance involves a dispute between neighbors. In an urban environment where neighbors live in close proximity to each other, everyone must, to some extent, tolerate some annoyance from the activities of neighbors. The law tries to strike a balance between the conflicting rights of a person to the reasonable enjoyment of a property and the right of neighbors to use their property how they wish. However, sometimes that balance is not reached and the plaintiff claims that rights have been infringed.
So now the multi-story building, generally the person those who are staying upstairs, if they are skipping, if they are making some of the noises, we could hear from the downstairs. The downstairs people could hear it. But sometimes in the night, if the glass falls over there, steel glass, so it produces a lot of noise also, you could hear it. Can you say that it is a nuisance? Yes?
No, sir.
Generally, we should have to forbear the annoyance of the neighbors. But the continuously they are making the whole night, then it become a nuisance. So here, examples of nuisance I have given: oil flowing from the service station onto a public footpath. Then the footpath becomes slippery and the people may fall because of the skidding. And the oil spillage affecting the river or offshore, foreshores. So unnecessarily, if the spillage would be there in the river or the sea, that will, because the wave will carry it to the shore, and the shore becomes a fully oily, where the people will not enjoy the swimming as well as the sunbath on the shore. So causing crowds or vehicle to block access to the roads or shops. So if a roadblock would be there, because of various other reasons. For instance, you take the accident, then there is also causes the public nuisance over there. The way a game is played, for example, golf, making the public right of access past the golf course dangerous. So if the public access would be there from the golf, even sometimes the ball may hit it, or sometimes the golf, the rod, if it comes out of the hand, then if it hits it, there is a very much danger will be there. Because the tip of the rod, there is a metal is there. So private nuisance, especially at the private places, when it is done or happened, then we can say it is a private nuisance. And here the nuisance by encroachment on a neighbor's land, it is also nuisance. Nuisance by direct physical injury to the neighbor land, it is also nuisance. Nuisance by interference with the neighbor's quiet enjoyment of his land. For instance, if you plant your tree, the tree branches protruded over his land, or the roots extended to his land, and where the wall is cracked because of these roots are cracked the foundation of their wall. So it is a indirect way of the trespass, hence we can say it is a nuisance. If the chimney fumes are passes to that entire the morning till the evening to your neighbor and causing inconvenience to them, then also it is a private nuisance. So proof of the damage is usually necessary in the nuisance, but when it comes to the matter of the trespass, it is an actionable per se. What is meant by actionable per se? Anyone? Anyone? If you know it, you tell me. If you don't know it, you say pass on. Yes.
Punishing without proof of damage.
You need not to prove the damage. The action itself is enough. And that is called actionable per se. Even the damage is happened, not happened doesn't matter. whether the infringement of your right is there or not. If you treat your leg on somebody's land, it is enough. If you make a flying kiss, it's enough by looking at somebody. If she is alone there or he is alone there. So proof of damage is not necessary over there. Here, what type of the nuisance is created in this image? Yes,
Private nuisance.
it's a private nuisance because it's a public plant. It's not a public place. It's the house, the reading room, and the upper side, the very sound is coming over there. Then we can say the private nuisance created over there. Then what about here?
Public nuisance.
If it is a public place should be there, then it's a public nuisance. And what is the nuisance going on here? What is the nuisance going on in this image?
Pass on, sir.
Dog is barking. What dog is doing?
Barking.
Can I say dog is crying? Yes, sometimes dog cries also. It is not a good omen. Examples of the private nuisance. Parking that obstructs the roadway. If your friend there is obstructs the roadway, then it is a private nuisance. In the public way, it is a public nuisance. Air pollution, open burning, animal poop, discarding the garbage, intolerable manner, it is a private nuisance. Land trespassing in your own land, private nuisance. Sound pollutions, late night drinking, parties, playing music, loud music, private nuisance. What about here? What about here?
Private nuisance.
What the action is going on here? What is the nuisance created over here? If you know it, you tell me. Don't waste my time.
Pass on, sir.
See, the lady, she put the two hands to her ears. Why? And the assistant and the man is sleeping. That means, say Pasan. That means, say Pasan. Say
Snoring.
Pasan.
Snoring, sir.
Snoring. మరి ఏం చెప్తలేరేంటి మరి దట్ మీన్స్ అంటే యు ఆర్ నాట్ సేయింగ్ ద స్నోరింగ్ రాసి కూడా ఉన్నది కదా ఇఫ్ యూ క్లోజ్లీ అబ్జర్వ్ ఇట్ యూ కెన్ సీ దట్ దెర్ ఇస్ ఎ స్నోరింగ్ because of snoring is there and causing a nuisance to them. Of course, you can make a ground for the divorce if you want, but generally the snoring is an involuntary act and hence it's not amount to the nuisance unless until it becomes a public at large. Why do you snore? A snoring can be caused by a number of the factors such as the anatomy of your mouth and sinuses, alcohol consumption, allergies, a cold, and your weight also. But the snoring will comes. These are the many other factors are there. So why I am showing all those things is since morning till evening you will create the many nuisances. Even spitting in the spit tune you have to spit it. But if you spit on the walls, you are creating a nuisance. Am I right?
Yes, sir.
Yes. So nuisance and remedies. We are living in a modern world where some degrees of nuisance is tolerable relating to noise, dust, pollution, smell, smoke, and escape of the effluents, etc. We are daily facing the various type of the nuisance and we ignore to some extent. Nuisance may come from your neighbors, your locality, and your state, or even from the various other authorities. A person in a position of the property is entitled to its undisturbed enjoyment as per law. However, if someone else improper use or enjoyment in his property ends up resulting in an unlawful interference with the enjoyment or use of that property of some of the rights over it or in connection with it, we can say that the tort of nuisance has occurred. Suppose in your garden, you are making a garden party but using the music in such a loud way that will be a disturbance to the other people, because adjacent neighbors, they are going to sit for the examinations. What are the examinations now going on now? Anyone? What are the exams are going on now in the Telangana state? Sir, we don't know, sir.
Degree SEM1 exams.
But why you are keeping quiet? You can say either school exam or the college exam or the university exam is going on. Sir, test is going on. There is a difference between a test and exam. Can you tell me? Anyone? Anyone? A test will be conducted by the individual lecturer, but exam will be conducted at the central level. So the term nuisance is made of the French word nuire and the Latin word nocere and the nocamentum, or which is a legal sense means annoyance or harm. Actually, it is a nuire. There is a term from the nuisance come from the French word. Nuisance defined in the free dictionary, one that is inconvenient, caused, or annoying, or vexation, or the use of the property, or course of the conduct that interferes with the legal rights of the others by causing the damage, annoyance, inconvenience, uncomfortable, are not favorable to his or his choice. A person or a thing or a situation that is annoying or that causes the troubles or problems is said to be the nuisance. Suppose if you sleep in a cot, it have the nallulu. English lo cheppandi. If you don't know, you say pasa. Don't waste my time. Yes? Say
Pass
pasa.
on.
Bed bugs. B-E-D, bed, bugs, B-U-G-S, bugs. So if there were a lot of bed bugs would be there, naturally you will feel inconvenient annoyance and you cannot enjoy. So the bed bugs causing the nuisance to you because it is not allowing you to sleep. If you sleep now, that will suck your blood. Am I right? Say yes. Say yes. So Wikipedia defines never use Wikipedia in your research work. I tell you, never use Wikipedia as your research work. You completely delete it because the intentionally I kept it. Now I am deleting in front of you because Wikipedia is a weak source of source because any person can edit it. So now don't use the Wikipedia, any references. A good lawyer, a good scholar, a good researcher never use that as a resource, as a acknowledgement, as a source of it. So now let us suppose we are living in a civilized society in which all are living together in harmony. If one of your neighbors starts behaving rudely, produces the noise, throw a garbage in the society, not ready to follow the rules of the society, and accommodate the same antisocial person or his or her residence, all these acts of your neighbor which cause annoyance, harm to you, and society is a type of the nuisance. Suppose if any person is alcoholic and daily he comes in the night and bangs the door and it causes a nuisance to the other people because the wife will sleep very thoroughly deeply and this fellow bangs and bangs and that will be a nuisance to each and everybody. Of course, intentionally, the wife also will not open the door. Why? 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 If you know, you tell me. If you don't know, you say pass on.
Sir.
Say pass on. Don't waste my time.
Pass
Sir, we
on,
are
sir.
thinking. See, the wife intentionally will not open the door. You know what is the reason? If it's banging, other people will make a nuisance to them and they will lodge a complaint in the police station. Use your brain. Reason. It is a very important factor. And It is a stigma also that everybody knows in the locality that he daily, the fellow, he drinks and comes on the banks the door and the causing the nuisance to them. Not only the wife should have to bring the notice of the police, even the neighbors will bring to the notice of the police every time it's causing the public nuisance to us. Even though it is a private nuisance, the public at large will be disturbed over there as it becomes a public nuisance. Did you get my point?
Yes, sir.
When I say asked, if you know it, you tell me. If you don't know it, just pass on without wasting the time. So definition of the nuisance is different in various words with many authors. Like the Stephen is one of the exponent in the law of Todd, he said in this way, to be anything done to the hut of or annoyance of the lands or tenements or hereditaments of another. Hereditaments means rights of easement called hereditaments of another, not amounting and not amounting to a trespass. That is not amounting to a trespass. That is amounting to a nuisance. Like if you cause an annoyance to your neighbor by playing your music at the 12 volume, sir, music is very much interesting, no, sir? Yes, it is very much interesting when you want to enjoy it. When you want to read for your examination, prepare for your examination, is it enjoyment to you? Say,
Sir.
is it enjoyment to you?
No, sir.
Why? Because you are preparing for the examination. Your interest is not in the music at the time. Is it clear? Say yes.
Sir.
Yes, say yes. Okay, the Blackstone nuisance is something that worked hard, inconvenience or damage. The Blackstone definition. Nuisance is something, something that worked hurt, means hurts the feeling, inconvenience or damage. Of course, somebody hurt feeling, it cannot be a nuisance. What is that case law which I told? That case law we can refer over here. But we discuss the case law. There is no damage, there is no legal injuries caused, even though there would be a damage. Can I tell the name of the case law? Can I tell the facts of the case law? Anyone?
Sir, grammar school, high school.
Is it a nuisance? Grammar school law is a Gloucester grammar school law is a nuisance.
Damage without injury.
Yes, but I said nuisance. Somebody's feelings were hurt in that movie, Jai Santoshima. What are the three goddesses? What are the three goddesses? It's shown in the movie, or they are jealousy to each other. The wife of Lord Vishnu,
Lakshmi. Parvati.
Jayaprada. And
Don't know, sir.
Saraswati, Lakshmi, Parvati. Three goddesses is shown having the jealousy to each other. So her feelings were hurt and she filed a case in the court of law for the injunction not to play that movie. What is the movie? Sir, Lavakusha. What is the movie? Say pass on. If you don't know, don't waste my time. Jai Santoshima. Jai Santoshima.
Okay.
What is the name of the case law?
Jai Santoshima versus State of West
No,
Bengal.
no, Jai Santoshima. Chitra Mandir, Bhagyalakshmi Chitra Mandir. But she is not, that is the Bhagyalakshmi Chitra Mandir is the producer of Jai Santoshima. Then what is the first name? What her name? Okay, now you come across, don't worry. So now Salman defined the wrong of nuisance consists of the causing or allowing without a lawful justification, but so as to common to trespass the escape of any dexterous things from his land, from the elsewhere into the land in position of the plaintiff. That is, the water escapes, smoke escapes, smell, fumes, gas, noise, heat, vibration, electricity, disease, germs, or animals. These are all causes the nuisance over there. Then Clark and Lindsay says nuisance in an act or omission which is an interference with the disturbance of annoyance to a person in the exercise or enjoyment of dash. What is right belonging to him as a member of public when he is a public nuisance, or his ownership or occupation of land or some easement, quasi easement, or the right used or enjoyed in connection with the land when it is a private nuisance. Suppose if he is enjoying the air, if he is enjoying the light more than 20 years, if anybody obstructs it, is according to a private nuisance over there. Nuisance has been defined under two categories, not two categories. I define in the many categories. Now, what we studied only the public nuisance and private nuisance only your syllabus is there. But I am giving some additional mixed nuisance, attractive or virgule alluring nuisance, anticipatory nuisance, or we can say another word, prospective. Prospective also we can say. Anticipatory, virgule, prospective nuisance, and the sixth is statutory nuisance. So generally our syllabus is having, what is our syllabus says? We are having
Nuisance, public.
only two nuisance we are having. Public nuisance and private nuisance. But I will let you give because some of them very easy to understand it and we are already studied when you are reading and that's why I am giving this one. So now let us see what is the public nuisance. If any act of a person annoys a large number of the persons or class of persons, it is called the public nuisance. When the many are annoyed, disturbed, inconvenience caused, at that instance, we can say public nuisance. Or any nuisance created in the public place, we can say it is a public nuisance. Right? Road accident is a private nuisance or a public nuisance? Yes.
Public nuisance.
It is a public nuisance, we can say it, because the public at the large are using the road. Like in the beginning, they have shown one or two, then the third will crash it, then three were there, the police were stopped, then creating a jam over there in the public, and hence we can say it is a public nuisance. So a public nuisance is an unreasonable interference. Why that accident happens? Can anyone can tell me? Quick, or say pass on. Either say or say pass on.
Pass on, sir.
See, the accident occurs. The judgment you can make it out, it cannot properly executed over there. You think that you can pass on, you can cover it. But meanwhile, your decision will not promptly allow the movie to go, then an accident occur. A judgment error, number one. Number two, if you are fully drunken, you cannot control your senses. At the time an accident happens. Number three, rash and negligence driving, because every road there is a KMPH is there. What is this KMPH?
Kilometer per hour.
Yes, there would be the school zone, KMPH 20, village zone appearing 20, and very close to the village 10. If the road crossing is there, there are bumpers are put it over there. Means road breakers. Speed breakers, they will keep it where there are people are passing over there. And the zebra crossing is there. Highway 100. Suppose if you are going to the ring road, do you know the ring road? Towards the Rajiv Gandhi International Airport. Sir, మేము కరీంనగర్ వదిలిపెట్టిపోలేదు సార్, మేము వరంగల్ వదిలిపెట్టిపోలేదు సార్, మేము ఖమ్మం వదిలిపెట్టి పోలేదు సార్, మేము కొత్తగూడెం వదిలిపెట్టి పోలేదు సార్, మాకు రింగ్ రోడ్ ఎక్కడ వెళ్తుంది సార్? టెల్ మీ. When you are going from the Varangal or Vijayawada, there comes the ring road. If you enter into the ring road, there are 4 lines are there. At least, yeah, I think 1, 2, 3 lines. Another is a ordinary line. There are 4 lines are there. So the first line adjacent to it, 120 kilometers you have to go. The second, I think 100. The another is 80. But anyway, there is a limit is there. So if a person wants to go the speed in that line, they has to go it. So in the ring road, of course, when you're using, you have to pay the toll tax also. Are you following me? Suppose if you don't maintain the speed, you are supposed to come to the another lane because another person wants to go with the speed. So anyway, that is if any accident happen on the highway, oh, it's very terrific. Not only 1, 2, 3. If the cars are more, they pile up the accident because they will come with such a speed. So it is the public place. It is happened over there. You can say it's a public nuisance. Under Section 3, subsection 48 of the General Class Act 1897, the word means a public nuisance defined by the Indian Penal Code. So they have given what is the public nuisance is given in the Indian Penal Code very clearly. So General Class Act will direct you to go to the public nuisance in the Indian Penal Code by the Section 3, which is a definition clause, and the 48 is a clause we can say here for time being, because every definition under it became a clause. So under Section 268 of the Indian Penal Code, 1860 provides that, I quote, a person is guilty of the public nuisance and who does any act, actually not does any act here. The mistake it is, does. Who does any act are guilty of an illegal omission which causes any common injury, danger or annoyance to the public or the public in general who dwell or occupy property in the vicinity or which must necessarily cause injury, obstruction, danger, annoyance to person who may have occasion to use any public right. I unquote. So what is the section 268 of the IPC says? Note, you read the note here. Anyone can unmute and read.
Note: if any person is injured due to an act of any person in the nature of public nuisance, that he or she can sue the person for damages as a private nuisance.
Suppose in the public nuisance, if a person has suffered more than the other people, then he can file the public nuisance as a private nuisance. Instances wherein an individual may have a private right of action in respect to a public nuisance. Number 1, for the public nuisance, a private individual having a file a case under the private nuisance. Number 1, he must show, means the victim, the plaintiff, he must show that the existence of any personal injury which is of a higher degree than the rest of the public, means he himself or herself is suffered more than the other people have suffered. That is number 1. Number 2, read.
Such an injury has to be direct and not just a consequential injury.
It will be a direct injury to be there, not probability or consequential injury. Number 3, the injury or harm must be shown to have huge effect. A lot of effect should be there, not merely a incision. It's a deep cut. It will be there. Let us see one of the case law. Sturgis versus Bridgman is a very classical case law. This is. If you not study the Sturgis versus Bridgman, that means you have not studied the nuisance at all. Because when the nuisance starts, this case law says, number 1, here say a confectioner had upward of the 20 years used. Who is a confectioner? A person who manufactures the candies chocolates, and such sweetened items are called confectioner. And he's preparing the candies or chocolates, and he is having 20 years the machine is there. Means the plant is there. Means factory is there. In the factory, the purpose of this business is they are using, what is the pestle and mortar? Do you know anyone? If you know it, yes.
Pass on, sir.
పెస్టిల్ అంటే ఇప్పుడు మనం ఇంతకుముందు ఫ్లోర్ లేనప్పుడు ఏం చేసేది, విలేజ్లలో దంచేది. ఏం దంచేది? ప్యాడీ దంచేది. దంచి ఏం చేసేది? రైస్ చేసేది. ఇజ్ ఇట్ నాట్? ఆ దంచేది ఉంటుంది చూడండి, దట్ ఈస్ వుడెన్ హ్యావింగ్ ఏ మెటల్ రింగ్ ఇన్ ద బాటమ్. ఏమంటారండి దాన్ని? రోలు రోకలి. రోలు అంటే హోల్ ఉన్నది, అంతే కదా. పెస్టిల్ మీన్స్ దంచడం ఉండేది, మోటార్ మీన్స్ ద హోల్ ఉండేది. సో ఐదర్ ఇన్ ద స్టోన్ దే విల్ మేక్ ద హోల్ ఏ హాలో, ఆర్ దే డూ హ్యావ్ ఏ సెపరేట్ కంటైనర్. ఐ విల్ షో యూ వాట్ ఈస్ ద పెస్టిల్ అండ్ మోటార్. దాన్ని పెస్టిల్ అండ్ మోటార్ అంటారు. దాన్ని రోలు రోకలి in Telugu. Your child is yeah. You mute it now. You mute it, so that I could not hear voice. So this is called pestle and mortar images. So now you can see, chusara, this is the pestle, this is the mortar. Means I am showing you only the small one. So that is it is run by the, nowadays we have the even a green red chilies will be used with the pestle and mortar. They do have a pestle run by the electricity. So the pestle and mortar would be there, and the confectioner using such a thing more than 20 years. For what? Sugar and flour. They will pound it with the pestle and mortar in his back premises, which abutted on the garden of the physician. So 20 years the confectionery plant is there, and a factory is there. In the back of it, the adjacent man has opened one consultancy. He's a physician. He's a medical doctor, and he's a MD physician, and he opened the consultancy. And then, so whenever you get any disease, you are not supposed to go anywhere. You have to go to the
doctor,
physician. The first and foremost, you have to go to the physician. The physician will make it clear to you. You go to the MS Ortho, you go to the ophthalmology, you go to the cardiology, you go to the neurology, you go to the urology. He will give guidance to you. It's the physician who gave you the guidance to you. So the physician, and the noise and the vibrations were not felt to be the nuisance, and complied until 1873. From until 1873 till he opened the clinic over there, he did not feel the nuisance. But when he opened this consultancy, the clinic, people like asthma people, if the people having the heart problem people, and the people having certain diseases, if they commit this pestle and mortar sound and a noise, and some of the dust also which comes over there, and that will be harmful to them. If you make a pass on a asthma patient from dry fish market, that fellow will die. Repeat.
asthma patient.
If you make him to pass through the dry fish market, ఎండి చేపల మార్కెట్ లోకి వెళ్ళి తీసుకుపోయింది అనుకోండి, that fellow will die on the spot, because it's a total allergic to him. So his allergic patients, they will die. If they are a long allergic would be there, then of course they cannot, suffocation would be there. For them, there is a suffocation would be there. So what I want to say is, until they have erected the consultancy room, before that it is not a nuisance. But when they erected and constructed the consultancy room and practicing from that date onwards, it's a nuisance. So the question for the consideration of the court was whether the confectioner had obtained the prescriptive right to make the noise is a question. So that fellow is enjoying it for the more than 20 years. That means law of prescription will work. Am I right?
Yes.
Am I right? Yes. Say yes.
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 But at that time, it is not a disturbance to him. It is not a nuisance to him. But when he opened the consultancy room, started the consultancy, from that day onwards is the thing. So from which day you got the annoyance, from that day the nuisance will start. Not your 20 years back. Is it clear?
Yes, sir.
So 20 years that you did not feel it is a nuisance, but when you constructed a consultancy room, from that day when you felt, not your patient felt, either you or your patients felt it, then from that day onwards the nuisance will be started. So that is the Sturgis versus Bridgman. You can read the entire case law in any book also, that will give you the good sense to you. A decided case of the Sultan versus D, this is another case law. The D held that the priest of a church, throughout the day, the bell of a church was ringing. Can anybody will ring the bell throughout the day? Yes?
No, sir. No.
Only the morning you can ring it.
Yes.
But this churchman is ringing the bell throughout the day and producing the sounded which affect the people living in the vicinity of the church. The plaintiff was the most affected person since his house was near to the church, and the court in this case decided that it's a type of the public nuisance and the plaintiff was entitled to the injunction. Not injection, injunction. See, the spelling mistakes. Injunction. Injunction. What is the spelling? INJUNCTION. Injunction means not to ring the bell throughout the day. When they have to ring the bells? Only in the morning. Okay, read this case now. Read.
Dr. Ramaraj Singh Babulal, AIR 1982, ALL 285.
What is the
The
mistake
defendant-
there? There is
West
some
is not
mistake is
there.
there.
West is not there.
See here,
And
Babulal
this 1982
versus
should be in the square
V
brackets.
Babulal AR.
And this should be in the square brackets, sir.
No, because when you say all, this is it all England reports? No, ALL means this may be the Allahabad law ALL. Allahabad, this is 285. So there will not be any AR doesn't have the square bracket. AR doesn't
Here
need the
should-
square bracket.
Here should be in the square brackets.
No, AR doesn't need the square bracket. Other SCC need the square bracket. Sorry, circular bracket.
1982 should be in the square brackets, no, sir.
All England report should be the square bracket. King's bench should be the square bracket. Hugh's bench should be the square bracket. Times law reviews the square bracket. Appellant cases should be the square bracket. But the all England reports, not the square bracket, not the circular bracket. Allahabad 285. So that is the way of writing. Only the Professor Hussain students can give the answer for such a thing. Okay, next. Continue.
The defendants had installed a brick grinding machine on his plot, and the plaintiff was a doctor and have a clinic adjoining the plot of the defendant. Due to brick grinding, the adjacent environment had polluted with the red brick materials, and same was visible on the dress of doctors, which affects the health of the persons residing in the vicinity of the clinic. The plaintiff brought a suit against the defendant for damages and got an injunction order from the court on the basis of public nuisance. Injunction spelling tough.
Injunction. Order from the
Yes,
court on the basis of public nuisance. Because the doctor has consulted a room over there. On the side, the brick kiln is there, grinding machine. Of course, the grinding machine is having the more than 20 years. Also, the standing would be there. But the nuisance started at the time when the brick grinding machine produces the dust, and it will be on the doctor as well as the patient. It's a red coating would be there on their faces, on their dresses also. The red brick material are the same visible on the dress of the doctors, which affect the health of the persons residing in the vicinity of the clinic, and the people at the large will be affected with this dust, which is in red in color, because the bricks when burned, it becomes a red. The plaintiff brought on a suit against the defendant for the damages and got an injunction order that let the clean would be the stopped. It would be from a faraway place. So కిల్న్ అంటే భట్టి అంటారు, కిల్న్ అంటారు, కేఎల్ కిల్న్ అంటే భట్టి, బ్రిక్ కిల్న్ ఆర్ బ్రిక్ గ్రైండింగ్ machine. In the same way, even though granite grinding machine also produces the sound as well as the dust, so that will also cause the damage to the lungs. Bronchitis, that is a disease, will come, especially the grinding machines or any dust which will affect the lung system. So next is in Leans versus Gordon, another case law. Yes, what is the mistake here? What is the mistake here?
In should 1943 should be in the square brackets.
1943 should be in the square bracket, not in the circular bracket. That is a mistake. So 1943, 1 means volume and a KB means King's Bench, 323 page. This is the style of writing the King's Bench, Queen's Bench, All England report, Times Law report, weekly report, appellate court. All those things should be in the square bracket. What year? Next, volume will come. Next, the journal name, report of names will come. Next, page number at the last. So the plaintiff, while walking on the highway, was injured on a Tuesday by glass falling from the window in an unoccupied house belonging to the defendant. So he is passing by the roadway on the path, the pedestrian path. So some of the window panes, I told you one day, the chip of a glass is called, the chip of a metal is called
Splinter, sir. Splinter.
splinter, I told you. So the splinter, the window having been broken in the air raid lo broken అయిపోయిందండి అది. And during the previous Friday night, owing to the fact that the offices of the defendant's agents were shut on the Sunday, and to the difficult of getting labor during the weekend, no steps to remedy the risk to passerby had taken until the Monday. The owner had no actual knowledge of the state of the premises. So whether it is a nuisance or not, answer is yeah, it is the Indian tradition that in the beginning or the ending of this any program that we will make the play of the national anthem. Now the national anthem will be.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात
अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।